Hello, everyone. Brainstorm TV1 Productions. We back. We back. So, how y'all doing today? So, we are back. Brainstorm TV1 Productions. Glad to see you. Glad you could be here. Glad you could join me. So, I want to say happy Sunday again. Hoping I'm hoping you are having a wonderful Sunday so far. I see the day is winding down and the work week is about to start. So, here on YouTube, a work day for us is every day. For some of us, anyway. A work day for some of us is every day. So, a lot of people, you run your own business, you promoting your own brand. Sometimes the work day for you is every day. But, some companies, some people work from from 9 to 5, Monday to Friday. But I guess I would say whatever makes you happy. So happy times are here again. So glad to see you all. Yes, it's all good. Glad you could be here. Glad you are joining me. So let me start acting crazy. Stop. And so the topic for today is what is a patent? Who needs a patent? And should companies get patents? So first of all, let's start out with what is a patent in simple terms. What is a patent in simple terms? A patent is the granting of a property right by a sovereign authority to an inventor. So you might be an inventor. I could be an inventor. Any of us can be inventors. So don't ever let don't ever let things happening around you, the way you was brought up, how you came up in the world. I mean, we all may have came up, less advantaged. We could have been more advantaged. We could have been less advantaged, but we should not ever let anything stop us from following our dreams, following our hopes, our dreams, and trying to achieve our goals. So if you want to create a patent, you want to be a new inventor, then hey, you want to start your own business, your own brand. You want to start your brand. You want to get a copyright. So in other words, you want to trademark your business brand name, products and services. You want to get a copyright for a book. You wrote a book. You want to get a copyright. And now you're talking about. Now I'm talking about, or you talking about. We all are talking about patents. So trademarks, copyrights, patents, they all come under intellectual property. So in other words, you're using your intellect, you're using your mind to create an idea, create a business, or create a product, or make an invention, build an invention. Say, for instance, you want to build a new model of airplanes. We have airplanes already going up. We have going up in the air. We have the Boeing 747. Whatever you want to invent, a new airplane. Whatever you want to invent. New vacuum cleaner, a new airplane, a new computer, a new telephone, a new type of telephones that is not even on the market. So let's get back into it. What is a patent? So it gives you the exclusive right. A patent is the granting of a property right. So you get that property right by a sovereign authority, to an inventor. This grant provides the inventor exclusive rights to the patented process, design, or invention for a designated period in exchange for a comprehensive disclosure of the invention. They are they are a form of incorporeal right. Government agencies typically handle and approve applications for patents. In the United States Patent and Trademark Office (USPTO), which is part of the Department of Commerce, and it handles applications and grants approvals. So in other words, you have an idea. You have an idea for a new product or a new process, a new way of doing things. A new product, a new process, and something unique that you want to get out of into the market because you feel that, hey, you feel that there's not nothing in the market there's nothing in the marketplace to satisfy that particular need. So you want to create that product. So you've been working on a product, you've been working on that process for the last 5 years. So now you want to offer that product or that process in the marketplace. So the key takeaways: a patent is the granting of a property right by sovereign authority to an inventor. So I guess when they say sovereign authority, I guess they talk about the U.S. Patent and Trademark Office. So those are the people that will prove or disapprove your patent. See, a patent provides the inventor exclusive rights to the patented process design. So it can be a process or design, like I said, or an invention, or invention for a certain period in exchange for a complete disclosure of the invention. In June of 2018, the U.S. Patent and Trademark Office issued its 10 million patent. Wow, in 2018, 10 million, 10 million patent. That was in 2018, the U.S. Patent and Trademark Office. So I guess it's supposed to be public knowledge. So I guess if we go to the United States Patent and Trademark Office, we can find out what that 10 million patent was. What was it? Yeah, so if you go to the United States Patent and Trademark Office, you can find out. You should be able to find out. We should be able to find out who was the inventor, of that patent in 2018. So, and also utility patents. They have something called utility patents. They're the most common patent issued in the United States, accounting for 90% of all issued patents. Then we have understanding patents. Most patents are valid for 20 years in the U.S. From the date the application was filed with the USPTO. Although there are circumstances where exceptions are made to extend a patent's term, U.S. patents are only valid in the United States and U.S. territories. So in other words, you have a patent, a particular new process. You have an invention, a process that no one else has probably came up with. And so you get that patent through the United States Patent and Trademark Office. So it would only be valid in the United States and the U.S. territories. So you would have to find out, where are these United States territories? So is it just the 50 states? So it says it's valid in the United States and the U.S. territories. So all the United States territories. If seeking protection outside of the United States, it is important to research the intellectual property rights of other nations and apply for protection with their governing authorities. So in other words, if you're trying to apply for property rights, intellectual property rights outside the United States of America, then you have to check with their laws. Mm-hmm. Check with their laws, because different countries definitely have different laws. So you have, different continents, different countries. They have their different laws. According to the United States Patent and Trademark Office, a patent can be granted to any person. So I can get me a patent. You can get a patent. We all can get a patent. So according to the United States Patent and Trademark Office, a patent can be granted to any person who invents or discovers any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof may obtain a patent subject to the conditions and requirements of the law. So in other words, you create something. In other words, what if you want to create a new type of computer that's not even on the market? You want to create you want to create a process that gets ink out your carpet, something, anything, but it's all good. So you just have to think about, if you want to, you have an idea. You going up in your memory and your brain, using your intellect, because this is definitely patents, trademarks, copyrights, patents, intellectual property. So your intellect, you're using your mind, you're using your brain. So invents, if you want to invent, you say for instance, you already invented it, or you could be working on it. You already invented it. You discover any new and you discovered a new and useful process. You discovered, like I said, machine, a computer machine, it could be a wash machine. You have a brand. You have a brand of wash machine that you created. You built your own brand of wash machines, and you want to put them out on the market. So whatever, so that's what they're saying. It could be, invented something. You have a new discovery. You have a new or useful process. You have a machine. When you have a machine, you built it. You manufactured it. You built it. Or composition of matter, or any new and useful improvement thereof may obtain a patent. So any useful improvement as well, something that can improve the lives of everyone, yourself, and a lot of other people. Types of patents. There are three types of patents available in the United States: utility patents, design patents, and plant patents. See, so I'm saying this information is new knowledge to me, because when I think about patents, I only think about, regular patents. But I'm saying when you do research and it's always information out there to learn. So there's always new information to learn. We have utility patents. Utility patents, or patents for invention, issue legal protection to people who invent a new and useful process. So you invented a new and useful process, that will come under the utility patents. So you have a process, like I said, of removing ink from the carpet, removing ink from the walls, whatever process, new and useful process. It has to be a new and useful process. Probably can't be a process that's already, definitely, it can't be a process that's already out on the market and someone else already has a patent for that, because that's patent infringement. So definitely it has to be new and useful, because if you try to go and replicate somebody else's patent that they have on the market, then that would be patent infringement. Utility patents are the most common type of patent, with more than 90% of patents issued by the U.S. government belonging to this category. So 90% issued by the United States government. So the United States government, they issued, it said 90% of patents issued by the U.S. government belonging to this category. Utility patents, they are the most common type of patent. And also a utility patent lasts for 20 years from the date of filing, as long as maintenance fees are paid. Maintenance fees are surcharges applied to utility patent applications filed after December 12, 1980. So we have, it talks about utility patents. Now they have design patents. Excuse me. So design patents are patents issued for original, new, and ornamental designs for manufactured products. Design patents protect the design or look of something. They require the invention to which the design belongs to be original and useful. So original and useful design patents. Design patents last for 15 years for applications filed after May 13, 2015. For applications filed before May 13, 2015, patents last for 14 years from the date of the filing. Maintenance fees do not apply to design patents. So in other words, if you have a utility patent, there are maintenance fees and surcharges. But for the design patents, there are no there are no fees. It says there are no well, it says maintenance fees do not apply. Okay, maintenance fees do not apply to design patents, but they do apply to the utility patents. So design patents are used for original, new, and ornamental designs. So it has to be new and ornamental designs for manufactured products. So manufactured products are products that you make. So in other words, you have to make a new design, to put in the marketplace, and that would be a design patent. Yeah, because that's almost common sense because it doesn't make sense to try to get a patent for a design that's already in the marketplace, and someone else already created that patent. Someone else is already the owner of that particular patent. So that doesn't really make any sense. And they have plant patents. So we have the design patents. We have design patents, utility patents, and now we have plant patents. We have plant patents. Patents go to anyone who produces, discovers, and invents a new kind of plant capable of reproduction. These patents are granted for 20 years from the date of filing, and no maintenance fees apply. In other words, you create a new plant. Ain't that something? You have the design patents, utility patents, and we have the plant patents. So plant patents, they go to anyone who produces and discovers and invents a new kind of plant. So if you discover and you invent a new kind of plant, so there are so many plants on in the market now. So if you can create or you produce, you discover, you invent a new kind of plant, maybe you introduce a plant that can talk. I don't know. Really? No, you introduce you manufacture or produce, you invent. So for instance, you invented a new plant that can grow without you watering it. I don't know if they have any of them on the market or not. A plant that can grow without any water for 5 years. Anything. It's all good though. But you have to think about something something unique, something unique, and something that's someone else doesn't have on the market. That's the idea of an invention. Alexander Graham Bell invented the telephone. We have, the invention of the computer when it came out on the market. So you can't go out on the market. You could come up with another computer, but your computer would have to do something different from any of these computers on the market. Anything you invent, basically, it has to do something different than the ones that's on the market. Say, for instance, you're working on a new vacuum cleaner. What is so different about your vacuum cleaner as opposed to the ones that's already on the market? The telephone, the iPhone. So cell phones was a good invention. That's a good, whoever got the first patent for those cell phones. Because I remember the cell phone, we didn't even have cell phones back, in the 80s? So, and then when we think about the cell phones, all of us probably thinking, wow, why did we think of that? And even I don't know if Uber and Lyft and Via got patents for rideshare, because that's rideshare is something we all been doing for years. So when rideshare came out, then I'm like, you think about that, you're like, what? That's something that we all probably experienced before they even made it a thing. So plant patents. So never even knew that they had anything called plant patents. So we have design patents, utility patents, and plant patents. And plant patents, they provide an incentive for companies or individuals to continue developing innovative products or services without the fear of infringement. So in other words, the last part of my question is already answered. It said, what is a patent? who needs a patent, and should companies get patents? And the answer is, that's the question, but the answer is yes, companies should. Depends on the individual needs of that company. So just like trademarks and copyrights, it depends on the individual needs of that particular company. They may need all three of them. They may just need one. So 9 times out of 10, all companies will need a trademark, but do they need a copyright? That's yet to be seen. Some companies may need all three. Some companies may need two. Some companies may need one. So it said patents provide an incentive for companies or individuals to continue developing innovative products or services without the fear of infringement. So, say for instance, like I said, you invented a new vacuum cleaner that it does something different than any of the ones that's on the market. So, I mean, you want to develop a business, you want to develop a brand on these new vacuum cleaners. So, these new vacuum cleaners, they're different than any of the ones on the market. But you're creating a brand, you're building a brand. You want to, memorable brand, a trustworthy brand, a brand that offers quality products and services. So in other words, you have these vacuum cleaners. It could be vacuum cleaners, whatever your invention is. But your idea is to start a business, start a brand from this invention. So it said patents provide an incentive for companies or individuals to continue developing innovative products or services without the fear of infringement. So without the fear of infringement, you get a new item that you created, that a new process or a new invention. You want to get a patent for it. You want to get a patent for it that way, and then you want to get a legal patent for it. So that will protect your business. So that would protect your business without fear of patent infringement. For example, large pharmaceutical companies can spend billions of dollars on research and development. So I always say that businesses definitely need to, market research, do market research. So companies spend billions of dollars on research and development, right? For research and development, they try to develop a new product, a new service, a new process, and they want to get a patent for it. They want to, increase revenue in their business by creating a item that they can patent, that they can put in the marketplace, they can make money off of. So I mean, that's a very good idea. Without patents, their drugs and medicines could be duplicated and sold by companies that didn't research or invest the needed capital for research and development. So, in other words, without patents, they're drugs and medicines. So, in other words, when it comes to drugs, medicines, and things of that nature, you definitely have to do your research. And then they have to test this medicine, test that medicine to see if it's going to work, see how effective this medication is, because they can't put nothing in the marketplace that's going to be harmful to the people, to the customers. In other words, patents protect the intellectual property of companies, right, to help their profitability. However, patents also serve as bragging rights for companies, demonstrating their innovativeness. So, in other words, patents protect the intellectual property of companies. So, in other words, like I said, you have a company and you're creating a new process, a unique process. In other words, a process, a way of doing things. Like I said, you have a new process for getting ink out of a carpet. You have, getting ink off the wall, or, wherever, whatever new process you have that's, currently not in the marketplace. So you want to get a patent for, to help the profitability of your company. Patents also serve as a bragging rights. Yeah, companies may brag about, being innovative, say, hey, I created this new product, and it does this and it does that, and there's nothing like it in the marketplace. So I want to market this invention because I want to get a patent, and then definitely make money, bring money into your business. definitely bring. So in other words, companies getting patents, trademarks, copyrights, and patents. So that's a way of increasing profits. Yeah, marketing this, and you know making their products and services available to the customer. Imagine a company having, or you or me or this company, that company. Imagine having, just inventing a process, that can do this and can do that, or a product that can do this or do that. That's not, on the marketplace. It has to be something new. And just imagine that, and how much money you can bring in, how much revenue you can bring into your company. I mean, you could be an individual person. You don't have to even be a business. If you are an individual person and you have an idea, you have idea for a new process, new product that can do this, can do that, and you did your research, and you checked on the trends in the market. You did your research, and you checked on all the trends in the market, and you found out that, hey, there's nothing on the market like this. I want to create this. I want to build this. I want to build this team to help me build this product, because I want to put it out in the market. I want it to help my business. I want it to bring in more customers. I want to continue to, brand this product. I want to brand this product. Right. I want to brand this product. So, in other words, you want to brand that product, and you bring in revenue for your company. In other words, patents protect the intellectual property of companies. Right. If you get a patent, you definitely will want to get a patent for that particular product. How to apply for a patent before making a formal application. An applicant should research the Patent and Trademark Office's database to see if another person or institution has claimed a patent for a similar invention. Right. That's why I said it has to be something new that no one else has on the market. Because if you invent something that someone else already has a patent for, then you could be faced with patent infringement. So that's why they said before making a formal application, do your research. Go to the trademark and Patent and Trademark Office's database and do your research. And then that way you can see, what inventions are already out on the market. And because 9 times out of 10, they're going to have everything in their database. They're going to have everything in their database. And it says the invention must be different from, that's what I was just saying, different from or an improvement upon a previous design to be considered for a patent. So in other words, right, it has to be different. It has to be, like I said, new, something that's not on the market. Because it don't make sense to try to get a patent for something that's already out there on the market. So that's why they say check the patent and trademark office's database, and that way you can find out. I think I'm gonna check it myself. I am going to check it myself because I never did it before, but I would definitely like to see all the products that are inventions, products, new processes, different processes for this and for that. I definitely want to see. So I will be checking the database. To apply for a patent in the United States of America, the applicant submits specific documents and pays associated fees. Written documentation includes drawings, descriptions, and claims of the item to be patented. See, written documentation includes drawings, descriptions, and claims of the item to be patented. A formal oath or declaration confirming the authenticity of the invention or improvement of an existing invention must be signed and submitted by the inventor. After fee payment, the application is reviewed and either approved or denied. So they can either approve your patent or deny it. Okay, patent statistics. The United States Patent and Trademark Office, it receives more than 500,000 patent applications per year, with just over 300,000 of them granted. Just think they get 500,000 applications per year, but they said with just over 300,000 of them granted. That's 200,000 that they probably didn't grant. They didn't. They said 500,000 applications, and they only, people turned in 500,000 applications, but they only granted 300,000. So there's 200,000 that didn't get their patent. But I mean, it's nothing wrong with go back to the drawing board and go back and try again. The agency has over 11,000 employees, whereby approximately 75% of them are patent examiners, while the remaining work in the legal and technical areas. In June of 2018, the USPTO issued the 10 million patent. The 10 million patent, that's in 2018, the United States Patent and Trademark Office. I would love to see what that 10 million patent is. Many patents issued go to companies in the technology industry, where Apple was granted 2,000 in 2018. So the Apple brand, they were granted 2,000 patents in 2018. Just imagine you filled out an application for 2,000 patents. So I mean, that's nothing unusual with the Apple brand, because we already know that every year they come out with a new Apple iPhone. So we have the iPhone, Apple iPads, the Apple computers. Microsoft and Google were also granted patents, of course. Microsoft and Google were also granted patents. However, IBM typically receives more than any company in the U.S. IBM was granted over 9,000 patents in 2017, alone, as reported by CNN Business. So, in other words, IBM received the most patents in 2017. They received 9,000 patents. I have to go look. I definitely have to go look, do my research. I definitely want to see what those 9,000 patents are. I know IBM has the computers, but what else did they patent? What else? I mean, it's all good. I'm telling you, it's this is so very enlightening, educational, informational. U.S. patent applications and grants, 1963 to 2020. So according to this chart, in 2020, it looks like 600,000. They granted 600,000. The U.S. Patent and Trademark Office, they granted 600,000 patents. Different companies, different people. 2020, and then I think it looked like 1970. They granted 100,000 patents. The U.S. Patent and Trademark Office. So examples of patents. One of the most notable patents in the past 40 years was a personal computer filed, and that's what I want to know. Okay, Steve Jobs. One of the most notable patents in the past 40 years was a personal computer filed in 1980 by Steve Jobs and 3 other employees of Apple Incorporated. So I don't know if it's still called Apple Incorporated. Is it just the Apple brand or is it Apple Incorporated? But Steve Jobs, 1980, so 40 years was the personal computer. So the personal computer. That's what I said. I knew computers wasn't available until like in the 80s. And that's what I said. I wasn't sure, but so yeah, so I said examples of patent. Okay, King C. Gillette. So King, the razor. King C. Gillette patented the razor and was dubbed a safety razor. Garrett Morgan was granted a patent for the traffic light. Garrett Morgan was granted a patent for the traffic light in 1923. So Garrett Morgan traffic light 1923. So in other words, Garrett Morgan. Then let's move down the page. The patent was it says Garrett Morgan, the traffic light, 1923. The patent for the television was issued in 1930. Patent for the television. Look, we wouldn't even be able to watch TV. Come on, thank you, Mr. Philo Taylor, Mr. Philo Taylor, 1930. Philo Taylor. I'm writing it down. FARNS. Where First TV. So Mr. So Garrett Morgan, the traffic light, 1923. Uh, and then we had the patent for the television. Philo Taylor Farnsworth for the first television system at age 20. He was 20 years old. Ain't that something? He was 20 years old. At age 20, Farnsworth had created the first electric television image and went on to invent an early model of the electronic microscope. So ain't that something? Patents versus trademarks versus copyrights. It says patents are legal rights issued. Patents are legal rights issued to inventors to protect their inventions for a certain time, usually 20 years. They exclude others from reproducing, using, or profiting from it without the express permission of the patent owner. The granting authority issues a patent in exchange for permission to publish details about the invention, such as how it's made and what it's used for. Right, how it's made and what it's used for. In other words, the granting authority issues a patent in exchange for the permission to publish. So in other words, you get a patent, and you're given the granting authority the permission to publish the details about the invention and how it's made, and what it's used for. So in other words, like I said, whatever you have an invention, any kind of invention, has to be something new, has to be something that's not on the market already. Something new, a process or a product. So your invention. Say for instance, you have a new, like I said, you have a new type of vacuum cleaner. You have a process, where you can get ink out of a carpet, ink out of someone's carpet, ink off the wall. You could have a new cell phone, a new type of cell phone that's never been on the market. So whatever kind of invention, that you can manufacture, you can make that has to be new. Has to be new. It can't replicate no one else's invention, no one else's. No, it can't. So it has to be something new. It says the granting authority issues a patent in exchange for permission to publish details about the invention, such as how it's made and what it's used for. And also, they're taking us back to our trademarks. Trademarks are legal protections on words. So in other words, patents are the legal rights issued to inventors. So you get a patent if you invent something. You get a trademark for your products and your business name, your products and services. So everything can represent your brand cohesively. So trademarks are legal protections on words, phrases, designs, or marks that identify a specific product or service. So that distinguishable mark for your business, that's when you get a trademark. In other words, like the brand Target, the brand Walmart, the brand Kmart, your brand, my brand, what if I have a brand called I have a brand called a brand something. You know, well, they already have Wrangler jeans and stretch jeans. So what do I have a brand called? I'm selling jeans. My brand is called Make Me Know It. You know, anything. My brand is my brand is called Make Me Know It. So in other words, I want to trademark for my brand name. I want to trademark for all the products in my product line, you know, so I can have the ownership of those, you know, of that trademark for those particular products in my brand. It gives me the right, the exclusive right. I own those products. I have a trademark for them. That gives me the exclusive right. No one else can come in and try to make money using my products or my services under their brand name, or they can't, you know, even try to use my brand, my brand name, my business name, and they try to make money, you know, from my business name. So that would be trademark infringement. Trademarks are intellectual property that contribute to the image and reputation of the product or service to which it belongs and to the company to which it belongs. Right. In other words, you have a trademark, you have that distinguishable mark for your brand. That distinguishable mark that represents and distinguishes your brand identity from the next company's brand. So that trademark, that distinguishable mark, that is your brand identity. It helps build. I mean, you know, you built a brand. You built a brand reputation that is unmatched. You know, and you know, it took hard. It took hard work, and then somebody come and try to create on your, you know, your products and your services or your brand name. Every company has their distinguishable trademark, trade name. Also it says a trademark can be incredibly valuable to a company, prompting some companies to include them in their evaluation. Trademarks are protected forever as long as it's in use and the holder can defend it. As long as it's in use. Like I said, you have a trademark for your products and services, as long as those products and services are in commerce. You're using it in commerce. You're using your products and services in commerce. You're making money. You know, that way other companies know that those are your products. Those are your products and services. Also at the same time, you have your distinguishable trademark on your products and your services. Your brand name, you know. So don't come and infringe on my trademarks for my company brand. Trademarks are protected forever, so that's good to know. As long as it's in use, I think you have to, according to my research, you have to. I think you just have to renew your trademark. In other words, it's protected forever, but you still have to renew it, and you have to keep using your products and services in commerce. So that gives you, you know, that's already giving you that protection, that legal protection. So, but you still want to get you know, the legal trademark, you know, in case something come along, some, you know, unforeseen problem come along in the future, and you have to end up in a lawsuit. You know, you have to sue somebody, or they trying to sue you. They could try to sue you and say you know, allegedly infringed on their trademark, and you could say the same. But you know, so trademarks are protected forever as long as it's in use and the holder can defend it. So long as it's in use, you know, you're using your products and services in commerce, you're selling, you're marketing, you're making those products and services available to the customer so they can see, so they can purchase. Customers can't see nothing, they can't see nothing. If they can't see nothing, they can't see your products and services, they can't, you know, they're not going to be able to purchase anything. They're like, I can't see what you have. I want to visualize your product line. I want to see what services you offer. Examples of trademarks include the Golden Arch. I always talk about that. The Golden Arch for McDonald's, the Nike swoosh, and the Apple's apple. Mm-hmm. That is the example I always use. Nike and McDonald's. The McDonald's Golden Arch, and it's the large M, the Golden Arch, and then they spell out McDonald's. So that's the trademark, trade name. We have Nike have their, you know, they all have a distinguishable mark. You know, you have to have a distinguishable mark. You don't want to have two businesses having the same trademark. That is ludicrous. Copyrights, and then that's trademark. So let's go down to copyrights. The legal protections on creative works. In other words, you write a book. Creative works of the mind. You write a book. You wrote a rap song. You wrote a movie. You're an artist. So that would come under the copyright. That get your legal protection under the copyright. So copyrights are protections for creative works of the mind, according to the United States Patent and Trademark Office, original works of authorship. Like I said, you write a book, authorship. They include visual art, literary works, other writings, also choreography, I didn't mention before, and also software. Like I was talking about software with the Microsoft Corporation. So 9 times out of 10, the Microsoft Corporation, they look to me like they may need all three, because they do sell software. So that would come under copyright for the software. And then they do have computers that they make, so they may have a patent for their computers, maybe, if they're building their own, I guess. And then definitely they would need a trademark, that distinguishable mark for the Microsoft brand, for their products and services. So they definitely would need a trademark, a distinguishable mark, so we could distinguish the Microsoft brand from the next company's brand. So they definitely would have to have a trademark that is distinguishable from their brand to the next, from one brand to the next. Okay, and also says copyrights are legal protections on creative works. Okay, and also they include visual art, literary works, other writings, choreography, and software. Okay, I read that. Copyrights prevent others from reproducing the work without the express permission of the copyright owner. Right, copyrights prevent others from reproducing the work without the express permission of the copyright owner. Like other intellectual property, copyrights are granted for a specific time, allowing the holder to benefit from its creation. Copyrights are granted for the maximum period of 70 years from once the author is not here, it's still 70 years after. Exceptions apply to works for hire and anonymous works. And also, they're going back into patents. The patent is a legal right to an invention. So in other words, a patent is a legal right to an invention. Then we have the copyright when you're dealing with copyrights. You're dealing in books. You wrote a movie. They just said choreography. In other words, choreography is that's like dance steps. So I guess you can copyright that. They mentioned that. So in other words, copyrights. You wrote a book. You're an artist. You're painting and sculpturing, painting. You wrote a book. You wrote a film, and so that would come under the copyright. And so you would get a copyright. Because I do have copyright for the books that I have written, and also then your patents. Your patents are you get a patent for an invention. So what are examples of patents? Examples of historic patents include common products that we use daily, including the telephone, dishwasher, and light bulb. Yeah, because you're right. The light bulb, the dishwasher, the telephone. Like they said, Apple created their patent for. I think they said it for their cell phones. No, it was the computers. Apple got a patent for their computer in 1980. But they also have cell phones too, though. The Apples have cell phones? Yes, they do. The Apple iPhone, but they didn't say when they didn't say when they had their they got their patent for their cell phone. They said the computer, 1980. So that's pretty much right. That's definitely right. So yeah, so that's most definitely right. So let's see what it say. What are examples of patents? Okay. Oh yeah, ones without expired protection include Boeing's water harvesting system. So they talk about patents. Patents without expired protection. That's the Boeing's water harvesting system, Disney's method for reproducing human actions with robots, and Google's medical response drone. So there is so much. So Google's medical response drone. So I know I heard about the drones, but I don't know who else, whatever company created a drone patent. But drones, I don't know. They haven't really been around that long. But I don't know but they say Google has a medical response drone that they do have a patent for. So that's very interesting. What are the three types of patents? You have the utility patent, the design patents, and the plant patent. So I went over those. Utility patents are issued for inventions that are novel and useful, right? Design patents protect the design or image of a product. Plant patents are issued to applicants for plants that can reproduce. So a plant patent, so I read over that, in other words, you have a patent for plants that can reproduce. Plant plant patents are issued to applicants for plants that can reproduce. I mean, this is very interesting too. Plants that can reproduce. So I figured that it definitely have to be. They have to do something that the other plants on the market is not doing. So these plants right here are new. They can reproduce. So in other words, these other plants can't reproduce. But you add water, but I mean they grow. Other plants. How much is a patent? Patents cost patents cost vary according to the type of patent applied for and are based on several other factors such as the type of applicant, provisional or non-provisional status, and associated fees, search fees, examination fees, post allowance fees, and more. There was a lot of fees for a patent. If using the services of an attorney, you can expect costs to range from approximately $5,000 to more than $45,000. In other words, if you want to employ a patent lawyer, trademark and patent lawyer, patent lawyer, it could cost you up to $45,000 just to employ a patent attorney. So if you have some attorney that's in your family, it would be good to use him or her. But so they say it can range from $5,000 to $45,000 to try to get a patent. I mean, I think I pass on that. How long does a patent last? Utility and plant patents last for 20 years from the date of filing, while design patents last for 15 years. It filed after May 13, 2015, or 14 years. It filed before May 13, 2015. Okay, the bottom line. So the end of the article. So patents are legal rights granted to inventors for their creations. Government divisions such as the United States Patent and Trademark Office issues patents and other intellectual property rights to U.S. citizens, right? So in other words, to U.S. citizens. So in other words, I guess if you live out of the United States of America, if you live out of the United States of America, you can't get a patent. You can't get a patent from the United States Patent and Trademark Office. So that's what it's like it's saying right here. Government divisions such as the United States Patent and Trademark Office issue patents and other intellectual property rights to U.S. citizens. Patent rights give exclusive rights to use, replicate, or sell the protected invention without interference from others who wish to do the same. Right. So you have patent rights. You have the exclusive right. In other words, you have that invention. You have the exclusive uh, right to use, replicate, or sell the protected invention. The issuing authority is granted the right to publish the details of the invention. So, in other words, where the United States Patent and Trademark Office, they have a right to publish how to use their product. In other words, you invented a product. Uh, in other words, that's what it said in exchange. You have to, they would publish how to use that product or that invention or that process. That way, the public will know. In other words, when we go to the database, we want to know. In other words, what is this product used for? What does it do? What does it do as opposed to something that's similar in the market? Something like that. But when you go to the database, you can find out all those things. Patents are granted for a limited time. That's 20 years. So this is like the end of the article. Patents are granted for a limited time, such as 20 years from the date of filing for plant and utility patents, and 14 or 15 years for design patents. Patents issued in the United States only offer protection within the United States. So patents, if you get a patent in the United States of America, right, you only get that protection in the U.S. I mean, that's common sense. To extend protection in other nations, the applicant must apply with the governing authority of that nation. So if you want to expand your protection for those other nations, then you have to check with the governing authorities in those other nations. So that's common sense. So that's the end of the article. So in other words, that's the end of the article. In other words, you want to get a patent, that gives you the exclusive right. In other words, you have an invention. You have an invention. You have a product you created. You have a process, a new process. You want to put on the market. You want to expand your product line, or you want to just start a business. Then you have a new invention. You have a process, a new process that you created. So that's what you get a patent for. But copyright, you get a copyright for a book, a film, a movie. Well, film and movie the same thing. Choreography, like I said, books. Also you can get copyright for you wrote a rap song. You wrote a rap song, it don't have to be a rap song. It could be a regular song. So that's what you get a copyright for. Then you get a trademark. You get a trademark for, your business name, your business product. So you create that distinguishable mark that distinguishes your brand from the next company's brand. So that sums it up. And so if you want, more information, you can always do more research. You can always do more research for, looking into uh, trademarks, copyrights, and patents. They all come under intellectual property. So you check with an intellectual property lawyer. But you see what I just read, how much it may cost you just to get a patent, starting out at $5,000 for a patent attorney, intellectual property. Well, I mean, I don't know if it's intellectual. I guess it would be an intellectual property law attorney. So intellectual property, in other words, your trademarks, your copyrights, and your patents come under intellectual property. So, mm, nice cold glass of water. Yes, a nice cold glass of water. So, an intellectual property lawyer. So they said to get a patent, it could cost you. To start out at $5,000, it could end up costing you 45,000. Big ones. Well, like I said, I pass on that. Patent, but it's good. Because sometimes they send you the little. Sometimes they send. Well, I know they have sent me little mail, letters and stuff, but they haven't sent them recently, but they have sent me before letters in the mail. They said, from a company, they said, if you have any inventions, you want to get a patent, so they sent me a letter, but they haven't sent any more recently, and I was trying to think of something that I can, I was trying to find something new for real. It's all good though. I'm telling you, I was trying to find something that I could call my invention. I was trying to create something because I'm like, wow, this seems like a great opportunity. It's great. This seems like a great opportunity because if I could have come up with a invention, something that wasn't on the market, what I was thinking, I was trying my hardest. I was trying hard as I could to find something something on the market that I could, call my invention. I can, call my invention. I was trying to, come up with something because they kept sending me the letter, but I'm like, I couldn't come up with nothing. I had a few ideas, but I just let it go. And then, after that, they stopped sending. I guess they probably figured she don't have no invention. We ain't gonna send her no more information, no more letters to try to get her, But it's all good. I was trying my best though, for real. But you never know. But so when it comes to trademarks, copyrights, patents, so if look into all three of them. Do your research. So dreams do happen. If you are ever thinking about opening up a new business, and you want to get a trademark for your products and services for your business name. So I mean, it's all good. It's just it depends. Follow your dreams, follow your heart. That's the only thing I can say. So I'm gonna close out on this video because it's getting late. It's almost 8:30 over here. So it's almost 8:30 in the U.S. But excuse me. So I ain't never had water to make me burp all the time, but this water right here is good though, nice and cold. So this is the spring water. Spring water. Mm-hmm. So I don't mess with no faucet water. Don't mess with no faucet water. So if I go to go to Walmart, the trusted brand, get all my water with the electrolytes and alkaline and electrolytes. Walmart, the trusted brand. So Walmart, you look at the logo, you look at the labels, you look at the products and services. So they have their distinguishable mark, the Walmart brand. When you look at their trademark, the distinguishable mark, that distinguishes their brand from the next company's brand. Well, I'm gonna close out right now, and I want to say thanks for joining me. Glad to see you. Glad you could be here. Glad you can join me. So I don't know. I'm trying to figure out why I'm not seeing why I'm not seeing, not, or how you see the people's name going across your screen that you can basically interact with your, I guess, potential subscribers, your subscribers, but I don't have that many, but I have a few, but I'm just trying to figure out why I'm not seeing it go across my screen, why I'm not being able to interact, So I'm trying to get my subscribers up. So I can't get my subscribers up if I can't see my, people's names going across the screen. I'm not able to interact. So I guess I have to go back and check. I have to go back and check because I checked before I started my live, and I clicked on this button and that button, and actually I can see on my cell phone where it says live chat, but I don't see anybody. I don't see anybody coming up for a live chat. But I guess I have to go in and do some more research and find out what is going on. Because I see live chat top messages, and I see the messages that I did put on there. So, but I don't see anybody else coming up. There's nobody that I'm interacting with. I only here talking. But it's all good. So I just have to go back. Sometimes you have to go back to the drawing board, do a little more research, and find out what is wrong, what is going on. So I want to say thanks for joining me. Thanks for joining me. Glad you could be here. Glad to see you. Hope to see you on my next video. So if you can comment, let me know what topics that I can bring forward on my channel. But other than that, I'm going to bring, some topics that I think that can bring some enlightening information, educational information. So I want to bring those topics forward, on my channel, So thanks for joining me. Hope to see you on my next video. And so not response, but I guess I would say my end phrase. My end phrase is going to be come back again. come back to see me again and Brainstorm TV1. So we out.